My name is Leroy Smith. I am a partner in the Bahamian law firm of Higgs and Johnson. I joined the firm in June of 2000, and over the next 2 decades, I worked in both the private client practice group as well as simultaneously the dispute resolution practice group. During that period, I had the distinct privilege of working with leaders in the local offshore trust industry, including Dr. Earl Cash and Philip Dunkley QC, both of whom are still with the firm in active practice, as well as Ms. Heather Thompson. So 20 years later, I've established a robust chancery practice, specializing or focusing on trusts and estates. I am the chair of Higgs and Johnson's Private Client and Wealth Management Group. Apart from being an idyllic location with I think quite inarguably the most beautiful beaches on the planet, the Bahamas is also recognized as being a world leader in financial services. We have always endeavored as a jurisdiction to provide international and private clients with superior products and services, and to deliver a world-class customer experience, all though within the ambit of, or within the context of, a well-regulated environment. We have, as a jurisdiction, proven ourselves to be nimble and capable of adapting to global developments. And at the same time, we have always been cognizant of the need to comport with international standards. Our location is, in my view, second to none. We are located at the crossroads of the Americas. We're situated just 65 miles to the east of Florida. As such, we provide an excellent point for, or location for, engaging in regional investments throughout the United States, as well as Canada, parts of Central America and South America. We have a myriad of international financial service providers in the jurisdiction that offer world-leading investment advisory, fund advisory, investment management, banking, private banking, and trust services. Additionally, as a jurisdiction, we are a tax-neutral jurisdiction. We have committed to being a tax-neutral platform or jurisdiction wherein international persons will receive the same tax treatment as will Bahamians. There is no income tax, capital gains tax, or inheritance tax. We do have taxation takes the form, however, principally of stamp duty in respect of real property transactions, and value-added tax at a rate of 12% in respect of goods and services rendered or purchased locally as well as imported. Higgs and Johnson's attorneys are accustomed to, on a daily basis, advising fiduciaries and high net worth individuals in respect of an array of trust services, ranging from the creation of complex trust structures, as well as the drafting of trust agreements and ancillary documentation, in addition to providing advice in respect of intricate matters of trust administration. In terms of what are our differentiating features, there are 3 points that come to mind immediately. The first is that we have a very deep bench, and by that I mean to say that we have, if not the largest private client and wealth management group in the jurisdiction, it is certainly among the largest. Size aside, we have deep and extensive expertise. Our private client and wealth management attorneys, we've been doing this for a very long time, and we are highly skilled, knowledgeable, while at the same time being approachable. Our attorneys have been involved in the drafting of most significant legislation currently underpinning the jurisdiction's the jurisdiction's trust regime, as well as the non-contentious probate regime. The third point that I wish to make is that Higgs and Johnson as a firm adopts a one-team philosophy. And as a result of that, the private client and wealth management group will, where appropriate, work collaboratively with other practice groups in order to bring cross-disciplinary expertise and resources to bear on our clients in order to enable us to provide the highest quality legal services to our clients in order to fulfill their needs in a cost-effective, efficient, and predictable manner. The development that comes to mind most readily has to do with the fact that COVID, it seems, gave most people, many people, a moment for pause and caused people to reflect, I suppose, perhaps on their own mortality or on their own personal affairs. And so we saw within the midst of the pandemic, within the midst of lockdowns and thereafter, an uptick, a marked uptick in planning instructions utilizing wills and trusts. The fact of the matter is that people took on the importance of ensuring that their wishes were adequately documented, and perhaps just as importantly, that arrangements had been put in place, proper arrangements had been put in place in order to ensure that those wishes would be effectuated. There are a lot. I'll pick three that are of particular interest to me. There has been a statutory codification of the rule in Hastings-Bass. There has been an amendment to the Trustee Act, which has enhanced the ambit of powers that can be reserved by settlers and other power holders under trusts. And then finally, there has been legislation that's been passed which serves to abolish the rule against perpetuities in this jurisdiction. I'll just summarize those briefly.
By all means.
So in the case of the first mentioned point, you'll be aware that following the decision of the English Court of Appeal in Pitt and Holt and Footer, the English Court of Appeal and Supreme Court came to reformulate the jurisdiction known as the rule in Hastings-Bass. And as a result, they reformulated the rule and substantially cut down the circumstances in which a fiduciary could have recourse to the courts to essentially be saved from or to set aside transactions executed in the course of in the course of a fiduciary's functions. So, following that, the Bahamian Parliament introduced a 2016 amendment to the Bahamian Trustee Act, which served to codify the rule in Hastings-Bass as it was understood prior to Pitt and Holt and Footer. And in so doing, it established a freestanding statutory mechanism by and according to which a fiduciary could make application to the court with a view to having, a fiduciary or other connected person could make application to the court with a view to having a given transaction set aside in circumstances where, or on the grounds that either relevant considerations were not taken into account or irrelevant considerations were taken into account. And so since that time, we've been instructed on various occasions on behalf of fiduciaries to, for example, bring court proceedings with the view to setting aside a given transaction on the basis that in circumstances where, for example, a trustee may have relied upon erroneous foreign tax advice, in circumstances where it would not have so acted had it been relying acting on the correct basis. So that's Hastings-Bass. The second point that I mentioned had to do with the amendment to the Trustee Act in order to introduce reserved powers. Under the Bahamian Trustee Act, Section 3 enumerates various powers that can be reserved to a settler whilst not invalidating the trust or causing a trust established inter vivos to be characterized as being testamentary. The introduction of Section 81A expands the scope of powers that can be reserved to a settler, and so specifically in circumstances where a trustee is invested with investment powers under a trust, those powers can be made subject to the direction or control of a settler by virtue of this statutory amendment. So that change has brought on a series of applications. We've been instructed on several occasions to apply to the court in order to vary the provisions of existing trusts in order to incorporate those reserved power provisions. The final development that I mentioned has to do with the abolition of the rule against perpetuities within this jurisdiction. And so the significance in a nutshell is that by the rule against perpetuities restricted the duration of a given trust. It put a cap on the amount of time that property could be held within a trust. And for persons from other jurisdictions, material tax consequences could ensue at the expiration of a trust, at the time that it came to an end, because it would be necessary to pay the money out, pay assets out, etc. Well, by abolishing the rule against perpetuities, as has been done, it enables settlers to create what are truly now legacy trusts that can go on for several generations. That's a significant development which has been of great interest to a number of clients. That abolition, though, only applies to trusts established post 30th December 2011. So for those trusts that were established before that time, the relevant statute that I've mentioned, the Rule Against Perpetuities Abolition Act, does make provision for an application to be made to court seeking an order serving to disapply the rule against perpetuities, as well as any earlier dispositions into that trust. And so those are three developments that have certainly been of interest to clients instructing us. Well, that's true. So I attended Trinity College School in Port Hope, Ontario. I then went on to England for several years. But the thought, and I loved those experiences, but the thought of living elsewhere was never a serious thought. I love, and we take this for granted, but I love the fact that I can look out the window in the morning and see the ocean. In my travels, I met and attended school with people who had never seen an ocean as a teenager, and so the Bahamas is a beautiful place. It's warm. The people are warm and inviting, and it provides a very nice and wholesome environment in which to raise your children.